Trump just refused a direct congressional order. For the first time in 248 years of American history, the House of Representatives voted to remove a sitting president from office, and he's not leaving. We're not talking about impeachment proceedings or symbolic censure votes. This is an actual removal resolution that passed with a constitutional majority, and the White House response was a four-word statement that sent shockwaves through every legal expert in the country. When 289 members of Congress, including 76 Republicans, vote to remove their own party's president, and that president responds by declaring the vote illegitimate, we've officially entered a constitutional crisis with no roadmap and no precedent. Hit that subscribe button right now, because what's unfolding in Washington over the next 72 hours will determine whether our entire system of government still functions. So what triggered this unprecedented vote? A leaked Supreme Court draft opinion revealed that 5 justices were prepared to rule that Trump's actions during the January 6th Capitol attack constituted what legal scholars call high crimes and misdemeanors sufficient for immediate removal under the 14th Amendment, Section 3. This isn't some obscure legal theory. This is the same constitutional provision used to bar Confederate officials from holding office after the Civil War. Sources who reviewed the 47-page draft opinion say Chief Justice John Roberts wrote in the majority decision that the evidence of direct coordination with militia groups to prevent the peaceful transfer of power represents a clear and present danger to the constitutional order that demands immediate action rather than waiting for the standard impeachment process. Here's what multiple constitutional law professors confirmed. The 14th Amendment, Section 3 states that anyone who previously took an oath to support the Constitution and then engaged in insurrection is automatically disqualified from holding any office. 3 legal scholars testified before the House Judiciary Committee on January 8th that this provision is self-executing, meaning Congress doesn't need a conviction or even an impeachment trial to enforce it. They just need a majority vote declaring that insurrection occurred. This wasn't about policy debates or standard political disagreements. This was about whether a president who allegedly coordinated with armed groups to stop the certification of an election can remain commander-in-chief while criminal prosecutions are still pending. Smash that like button if this is making sense so far. Here's where it really gets serious. The Supreme Court draft opinion leaked to the press on January 6th contained something legal analysts say they've never seen before: text messages between the president and leaders of 3 separate militia organizations discussing specific timing for breaching the Capitol and preventing Mike Pence from completing the electoral count. Justice Amy Coney Barrett reportedly wrote a concurring opinion stating that while she had defended executive privilege in past cases, these communications showed such a direct threat to constitutional governance that normal protections simply cannot apply when the presidency itself is being weaponized against the constitutional order. And let's be honest for a moment, removal votes like this don't happen over political disagreements or policy disputes. They happen when lawmakers from both parties believe a president poses an immediate danger to national security and constitutional stability. Here's what multiple sources say happened next. On January 9th, House Speaker Mike Johnson convened an emergency joint session after the Supreme Court leak hit the news. Republican leadership held a closed-door meeting that reportedly lasted 6 hours. Sources told reporters that Johnson himself, who had consistently defended Trump through 2 impeachments and multiple investigations, stood before the Republican caucus with a copy of the leaked Supreme Court opinion and said the evidence of coordination with militia groups was so damning that defending it would destroy the party's credibility for a generation. Meanwhile, Congressman Jamie Raskin, the constitutional law professor serving on the Judiciary Committee, presented a detailed legal memorandum arguing that Section 3 of the 14th Amendment requires Congress to act immediately when evidence of insurrection is clear, regardless of pending criminal cases. By the end of that session, 76 Republicans had privately indicated they would vote for removal if the resolution came to the floor. The resolution was introduced on January 10th at 9:47 a.m. Eastern. The language is extraordinarily direct. It states that Donald J. Trump engaged in insurrection against the United States by coordinating with armed militia groups to prevent the peaceful transfer of presidential power, that this conduct violates his oath of office and disqualifies him under the 14th Amendment, and that he is hereby removed from the office of president effective immediately upon passage of this resolution. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely wild. The debate on the House floor lasted 11 hours. Republican Congressman Adam Kinzinger, a former Air Force pilot who served on the January 6th committee, gave a speech that reportedly brought several members to tears. He held up his military dog tags and said that every service member swears an oath to defend the Constitution against all enemies, foreign and domestic, and that he could not in good conscience allow a commander-in-chief to remain in power when the Supreme Court itself has found evidence he coordinated an armed attack on the constitutional process. That's when it became clear this isn't just another political scandal. The bombshell moment came at 8:34 p.m. when the final vote was tallied. 289 members voted for removal. 146 voted against. The constitutional threshold was exceeded by 72 votes. Reporters in the chamber say the House floor went completely silent for nearly 30 seconds as members absorbed what had just happened. For the first time in American history, Congress had voted to remove a sitting president not through impeachment and conviction, but through a direct constitutional disqualification for insurrection. Within minutes, legal experts were on every network explaining that under Section 3 of the 14th Amendment, Trump is now constitutionally barred from holding the office of president. This move sent shockwaves through Washington. When 76 Republicans vote to remove a president from their own party, it signals one thing. The evidence is so overwhelming that political survival now depends on distancing yourself from actions that the Supreme Court has deemed insurrectionary rather than defending the indefensible. The argument that this is a partisan witch hunt completely collapses when more than a quarter of the president's own party is voting for his removal based on evidence documented in a Supreme Court draft opinion written by justices he himself appointed. This isn't the first time Congress has faced removing a president who refused to accept constitutional limits. Think back to Richard Nixon during Watergate when the House Judiciary Committee passed articles of impeachment. Senior Republican leaders went to the White House and told Nixon he would be convicted in the Senate and had to resign. Nixon understood the constitutional process and stepped down within 48 hours. Then there was the first Trump impeachment over Ukraine in 2019. While he was acquitted in the Senate, he accepted the legitimacy of the process and continued governing. The key difference is that in those cases, the president acknowledged that Congress had the constitutional authority to hold him accountable even if he disagreed with the outcome. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget Andrew Johnson's impeachment in 1868. He came within one vote of being removed from office by the Senate. Johnson opposed the impeachment and called it a political attack, but he accepted the Senate's authority to conduct the trial and abided by the final verdict. Now, however, it's different. This time, the president is refusing to acknowledge that the vote has any legal force whatsoever. The pattern is clear. When presidents face constitutional accountability mechanisms, they may fight the charges, but they ultimately accept the legitimacy of the process itself. Once a president declares that constitutional votes by Congress are illegitimate, we've entered genuinely unprecedented territory where the entire framework of checks and balances is at stake. So what triggered this extraordinary refusal? According to sources inside the White House, Trump was meeting with a team of constitutional lawyers when the vote results came through. One attorney reportedly told him that Section 3 of the 14th Amendment is self-executing and that the House vote means he is legally disqualified from holding office effective immediately. Trump allegedly responded by throwing a briefing book across the Oval Office and shouting that he would not recognize the authority of a corrupt Congress to remove a president who won the election. The memo his legal team released at 9:15 p.m. was 4 sentences long. It stated that the House vote was unconstitutional, that only the Senate can remove a president through the impeachment process as outlined in Article 2, that Section 3 of the 14th Amendment does not apply to the presidency, and that Trump remains the legitimate president of the United States. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone. This isn't just about one vote or one constitutional provision. If a president can simply refuse to accept a removal vote by Congress, on the grounds that he personally believes it's unconstitutional, the entire system of checks and balances instantly collapses. Once that precedent is set, there's no turning back. Every future president facing accountability can declare that whatever mechanism Congress uses is illegitimate and refuse to comply. This means the fundamental principle that no one is above the law, including the president, evaporates completely. This puts Republicans in Congress in a nearly impossible position. On one side, they feel pressure to maintain support from a base that remains fiercely loyal and sees the removal vote as a betrayal. That means defending Trump's refusal to leave office, attacking the Supreme Court leak as illegitimate, act and framing the entire situation as a deep state coup. On the other side, they are forced to reckon with the fact that 76 members of their own caucus just voted to remove the president based on evidence from a Supreme Court draft opinion. They now have to explain to voters why constitutional removal provisions should be ignored when the evidence of insurrection is documented by the highest court in the land, a position that's nearly impossible to defend. And here's the tricky part: there's no credible legal defense. Either the Supreme Court draft opinion accurately reflects the evidence of coordination with militia groups, in which case Section 3 disqualification is constitutionally required, or 5 Supreme Court justices, including 3 appointed by Trump himself, are fabricating evidence in a draft opinion, which would require believing an absurd conspiracy theory. Constitutional scholars are calling this the most serious threat to American democracy since the Civil War. A Yale law professor and former Solicitor General told news networks that if a president can refuse to accept a constitutional removal vote by Congress, we no longer have a republic governed by law, but rather a system where the president's personal interpretation of the Constitution supersedes the authority of the legislative branch. A former federal judge added that Trump's legal argument that Section 3 doesn't apply to the presidency contradicts 150 years of constitutional scholarship and recent Supreme Court precedent. The provision explicitly states it applies to anyone who previously took an oath to support the Constitution, which unquestionably includes the presidential oath. Claiming that the presidency is somehow exempt is constitutional nonsense designed to justify refusing to leave office. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even a conservative legal scholar who defended Trump during both impeachment trials admitted that the refusal to accept the House vote creates a constitutional crisis without precedent. He emphasized that while there are legitimate legal debates about whether Section 3 can be enforced through a House vote alone, once that vote occurs, the proper remedy is to challenge it in court, not to simply declare it void and refuse to comply. The president's personal belief that the vote is unconstitutional doesn't give him authority to ignore it any more than a defendant's belief that a conviction is unjust gives them authority to ignore a court order. So let's break down what this could mean. First, the immediate political impact is staggering. There are now 2 competing claims to the presidency. The House of Representatives has voted to remove Trump under the 14th Amendment, Section 3, which means under constitutional law he is disqualified from holding office. But Trump is refusing to leave and claiming the vote is illegitimate. This creates a situation where the Secret Service, military leadership, cabinet secretaries, and federal agencies have to decide which authority they recognize: the constitutional vote by Congress or the president's refusal to accept it. Second, it creates an immediate crisis for the military chain of command. Active duty service members swear an oath to support and defend the Constitution, not to obey any individual president. If the Constitution, through Section 3, disqualifies Trump from holding office and Congress has voted to enforce that provision, military commanders face an impossible choice. Do they follow orders from someone who may no longer be constitutionally authorized to serve as commander-in-chief, or do they recognize the House vote and refuse to take direction from Trump? A poll of active duty officers conducted 24 hours after the vote found that 61% believe the military should not follow orders from a president who has been removed by Congress under constitutional authority, a staggering crisis for civilian control of the military. Finally, looking ahead, the broader constitutional implications are existential. This fundamentally changes the nature of presidential power. If Trump successfully refuses to leave office despite a constitutional removal vote, it means future presidents can ignore congressional accountability mechanisms simply by declaring them unconstitutional. Impeachment, the 25th Amendment, Section 3 disqualification, all become meaningless if the president can refuse to recognize them. This doesn't just affect Trump's presidency, it affects every presidency going forward because it establishes that constitutional constraints on presidential power are optional if the president is willing to defy them. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate political fallout, this is really about whether our constitutional system still functions. The framers designed a government where no branch has absolute power and where mechanisms exist to remove leaders who violate their oath of office. Section 3 of the 14th Amendment was added specifically to prevent people who engage in insurrection from holding positions of public trust. If a president can coordinate with armed militia groups to stop the constitutional process and then refuse to accept Congress's vote to disqualify him under that provision, the Constitution itself becomes a suggestion rather than the supreme law of the land. If a president can defy a removal vote on the grounds that he personally disagrees with the constitutional interpretation, civilian accountability for the executive branch effectively ceases to exist. The implications for American democracy would be catastrophic. This scenario is causing absolute panic within Republican leadership. Reports indicate that Senate Minority Leader Mitch McConnell held emergency calls with constitutional scholars to determine whether the Senate must now hold a separate vote to enforce the House removal resolution. Some Republicans argued for supporting Trump's position that the vote is unconstitutional and attacking the process as illegitimate. Others insisted that refusing to recognize a constitutional vote by the House of Representatives would permanently destroy the party's credibility as defenders of constitutional governance. Meanwhile, core supporters are absolutely livid at the 76 Republicans who voted for removal. Social media is flooded with calls to primary every single lawmaker who broke ranks. They're being labeled traitors and deep state operatives. To the base, this is the ultimate betrayal, proof that even Republicans can't be trusted to defend the president against what they see as a coordinated coup by the political establishment. Things escalated further when Trump addressed the nation from the Oval Office at 11:47 p.m. on January 10th. He called the House vote a sham and an illegal attempt to overturn the will of the American people. He claimed that Section 3 of the 14th Amendment was never intended to apply to the presidency and that the Supreme Court leak was fabricated by intelligence agencies to provide cover for a congressional coup. He specifically named the 76 Republicans who voted for removal and called them cowards and rhinos who would face severe political consequences. And then he declared that he would continue serving as president regardless of the House vote because the American people elected him and no corrupt Congress could overturn that mandate. Stay with me. What comes next will completely change how you view the situation. Here's what makes this even more extraordinary. Trump's own response essentially admitted that he has no legal defense. Instead of presenting a constitutional argument for why Section 3 doesn't apply or why the evidence of coordination with militia groups is inaccurate, the entire response was attacking the process and the people who voted for removal. When your defense is declaring that constitutional votes by Congress are illegitimate coups rather than actually disputing the underlying evidence, you've already conceded that you have no credible legal argument. Legal experts immediately flagged the problem. Calling a constitutional removal vote a coup while refusing to leave office creates an absurd contradiction. A coup is an illegal seizure of power. Congress voting to enforce Section 3 of the 14th Amendment is the opposite of a coup. It's the constitutional process functioning exactly as designed to remove someone who engaged in insurrection. If Trump believes the vote is unconstitutional, the remedy is to challenge it in federal court and ask for an injunction, not to declare himself above congressional authority and refuse to comply. This goes far beyond a single controversy. It's about whether a president can simply ignore constitutional accountability mechanisms by declaring them illegitimate. If there are no consequences for refusing to accept a removal vote by Congress under the 14th Amendment, it signals that presidential power has no meaningful constitutional limits. It's not just about Trump's presidency. It's about whether the Constitution itself still constrains executive power or whether we've entered an era where presidents can defy congressional authority whenever they personally disagree with it. If this blows your mind, hit that like button right now. Here's the situation. 289 members of Congress, including 76 Republicans, have voted to remove Donald Trump from office under Section 3 of the 14th Amendment based on evidence documented in a leaked Supreme Court draft opinion. Trump has refused to accept the vote, declared it unconstitutional, and stated he will remain president. We now have two competing claims to presidential authority, one based on a constitutional removal vote by Congress and one based on a president's refusal to recognize that vote. When the House of Representatives exercises its constitutional authority to disqualify someone for insurrection, and that person responds by defying the vote and claiming it's a coup, we've entered a constitutional crisis that has no precedent in American history. If there are no consequences, it sets a catastrophic precedent. Future presidents could refuse to accept impeachment convictions, 25th Amendment invocations, or any other accountability mechanism simply by declaring them illegitimate. The entire framework of checks and balances collapses once a president decides constitutional constraints are optional. Keep a close eye on this story. The Supreme Court is reportedly holding emergency sessions to decide whether to issue a ruling on the House removal vote before the leaked draft opinion becomes official. Legal teams representing Trump have filed motions in federal court seeking injunctions against enforcement of the removal resolution. And military leaders are facing the impossible question of whether they should continue taking orders from someone Congress has voted to disqualify under constitutional authority. And now the situation has escalated even further. Sources inside the Pentagon report that Defense Secretary Lloyd Austin convened an emergency meeting with the Joint Chiefs of Staff on January 11th at 6:00 a.m. to address the chain of command crisis. According to two generals who were present, Austin opened the meeting by stating that the military faces an unprecedented dilemma. Congress has voted to remove the commander-in-chief under constitutional authority, but that individual is refusing to recognize the vote and continues issuing orders as if he remains president. The question that hung over the room was simple but terrifying. Who do we take orders from now? General Charles Brown, chairman of the Joint Chiefs, reportedly told the group that the military's oath is to the Constitution, not to any individual, and that if Section 3 of the 14th Amendment has been properly invoked by Congress, the military cannot continue following orders from someone who is constitutionally disqualified from holding office. But another general raised the counter-argument. If the president believes the House vote is unconstitutional and plans to challenge it in federal court, should the military preemptively refuse orders before the courts have ruled? That creates its own constitutional crisis because it means unelected military officers are making legal determinations about who holds legitimate executive authority. This is the nightmare scenario that keeps constitutional scholars awake at night. When there's a dispute about who legitimately holds presidential power and both sides have plausible constitutional arguments, who decides? The answer in a functioning democracy is supposed to be the courts. But what happens if Trump refuses to accept a court ruling just as he's refusing to accept the congressional vote? At that point, you have a president who has placed himself above all three branches of government, Congress, the courts, and the constitutional provisions they're sworn to uphold. And here's where things get even more complicated. Reports emerged on January 11th that Vice President J.D. Vance met privately with Speaker Mike Johnson to discuss the possibility of invoking the 25th Amendment to resolve the crisis. The 25th Amendment allows the Vice President and a majority of the cabinet to declare the president unable to discharge the powers and duties of his office. If Vance were to invoke this provision and gain cabinet support, he would immediately become acting president, and Trump would be legally removed from power through a completely separate constitutional mechanism from the Section 3 vote. Sources say Johnson told Vance that invoking the 25th Amendment in addition to the Section 3 removal vote would create an ironclad legal case that Trump no longer holds presidential authority. But Vance allegedly expressed concern that taking such a step would be seen as the ultimate betrayal by Trump's base and could trigger violent protests or worse. This is the impossible calculation facing Republican leaders right now. Do they allow a constitutional crisis to continue because they fear their own voters, or do they use every available constitutional tool to resolve it, even if it means facing political destruction? Meanwhile, federal courts are being flooded with emergency filings. Trump's legal team filed a motion in the D.C. Circuit Court on January 11th seeking an immediate injunction blocking enforcement of the House removal vote. The filing argues that Section 3 of the 14th Amendment requires a criminal conviction for insurrection before it can be applied, and that Congress cannot simply vote to disqualify someone without due process. But legal experts immediately pointed out the flaw in this argument. The Supreme Court ruled in 2024 that Section 3 is self-executing and does not require a criminal conviction. The leaked draft opinion that triggered this entire crisis explicitly reaffirms that precedent. At the same time, a coalition of constitutional law professors filed an amicus brief arguing that Trump's refusal to accept the House vote constitutes contempt of Congress and potentially obstruction of constitutional proceedings. They argue that if a president can ignore removal votes simply by declaring them unconstitutional, Congress loses all ability to enforce accountability, and the separation of powers becomes meaningless. The D.C. Circuit has scheduled emergency oral arguments for January 13th, meaning we could have a federal court ruling on the legitimacy of the House removal vote within 48 hours. This is history unfolding in real time. Every decision made in the next 72 hours will determine whether our constitutional system survives this crisis or whether we've permanently entered an era where presidential power has no effective limits. The stakes couldn't be higher. And the entire world is watching to see if American democracy can withstand a president who refuses to accept constitutional accountability. And there's another layer to this that nobody's talking about yet. The international implications are absolutely staggering. Foreign governments are watching the United States descend into a constitutional crisis where the legitimacy of presidential authority is being disputed in real time. Reports from the State Department indicate that at least 7 allied nations have quietly contacted the Secretary of State asking for clarification on who they should recognize as the legitimate president of the United States. This isn't just an internal political crisis. This is a question that affects military alliances, treaty obligations, nuclear command authority, and America's standing as the leader of the free world. A former ambassador to NATO told reporters that if America cannot definitively answer the question of who holds presidential power, our allies will begin making contingency plans that don't depend on American leadership. That means reconsidering defense commitments, questioning the reliability of intelligence sharing, and potentially seeking security arrangements that bypass the United States entirely. When your closest allies can't determine who legitimately holds executive authority in your government, your credibility as a global superpower evaporates overnight. This constitutional crisis isn't just about domestic politics. It's about whether America remains a stable, predictable partner in a world that depends on American institutions functioning properly. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. 289 elected officials just voted to remove a sitting president under the 14th Amendment, Section 3. That president is refusing to leave and declaring the vote illegitimate. Federal agencies, military commanders, and the Secret Service are trying to determine which authority they recognize. Meanwhile, the Supreme Court is preparing to rule on whether a president who coordinated with armed militia groups to prevent the peaceful transfer of power can remain in office while claiming that constitutional removal provisions don't apply to him. This isn't just another news cycle that will fade away. This is the most serious constitutional crisis in American history unfolding in real time. What happens in the next 72 hours could determine whether the presidency is still subject to constitutional constraints or whether we've entered an era where executive power has no meaningful limits. The House has voted, Trump has refused. Now we wait to see if the Constitution still means anything when a president decides to defy it. The stakes have never been higher. The constitutional crisis has never been more immediate. And the question of whether our system of government can survive a president who refuses to accept accountability has never been more urgent. Pause for a second and hit that like button if you're finding value in this coverage.